The Judicial Efficiency Act of 1990, the cancer in our courts. The Judicial Efficiency Act of 1990 was sold as a reform to streamline the judicial process, but in reality, it has become the greatest weapon used to silence constitutional challenges. Instead of ensuring justice, this act has enabled courts to dismiss cases on procedural grounds, blocking individuals from having their constitutional claims heard. For over 3 decades, this act has been used to suppress First Amendment petitions, deny due process, and shield government misconduct from judicial scrutiny. Courts no longer rule on the Constitution. They rule on technicalities designed to shut the courthouse doors before constitutional violations can be reviewed. In Belous versus City of Battle Creek, we see how procedural fraud is used to evade accountability. The city attorney misrepresented the legal status of Code Compliance Officer Yolanda Johnson, claiming she was just an employee when, in reality, her duties directly coincide with those of a public officer. Under Michigan Constitution Article 11, Section 1, and MCL 15.151, all public officers must take an oath before exercising any enforcement power. By deliberately misrepresenting her status, the city attorney fabricated a defense to justify enforcement actions taken by an officer who never had the legal authority to act. This is fraud on the court, a deliberate misrepresentation designed to suppress a constitutional challenge. As the U.S. Supreme Court ruled in Hazel Atlas Glass Company v. Hartford Empire Company, 322 U.S. 238, 1944. Fraud upon the court vitiates even the most solemn judgments. The same tactic was used when the city fabricated a fraudulent notice of intent to dismiss, misleading the court into dismissing Belous' case. This false procedural ruling was then used to discredit him, ensuring that his constitutional arguments were never heard. But the Judicial Efficiency Act of 1990 is not the only legal doctrine crumbling. E.M.D. Sales Incorporated v. Carrera, 598 U.S. _ 2025, struck down the use of procedural dismissals to obstruct constitutional adjudication. The Supreme Court ruled, courts must not use procedural mechanisms to evade substantive constitutional review. This is exactly what happened in Belous versus City of Battle Creek. Instead of addressing the constitutional violation, the court hid behind procedural games, allowing an unsworn officer's unlawful enforcement actions to stand unchallenged. The Department of Justice confirmed these abuses in its February 20, 2025 notice, which warns, courts have systematically dismissed valid constitutional cases without addressing the issues. The Judicial Efficiency Act of 1990 has been misapplied to favor judicial efficiency over constitutional rights. Procedural dismissals are being weaponized to prevent individuals from challenging government misconduct. This is why judicial reform must happen now. Just like the Chevron doctrine was overturned in Loper Bright Enterprises versus Raimondo, 2024, it is time for the Judicial Efficiency Act of 1990 to be reviewed, challenged, and dismantled. If courts continue to prioritize judicial efficiency over constitutional rights, then the Judicial Efficiency Act of 1990 must be struck down. The Constitution was written to protect the people, not the government's ability to avoid accountability. Justice delayed is justice denied. The time for change is now.